1 CR 0835, State of Texas versus Nicholas Cornelius. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
As judge, we're going with the lesser included offense robbery.
Any objection?
No.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to accept your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge. I believe he's competent.
Do you believe he's yes. Do you believe he was legally sane at the time of the offense? Mr. Cornelius, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of robbery, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and no contact with Jose Aguilar. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers exhibit 1 in all offense.
No objection.
All right. And state, have you been in contact with the complainant?
So we have been in contact with the complainant, Your Honor. There were other co-defendants in this case. One of them also did have the charge reduced to robbery and was given to her.
All right. Thank you. Oh, you may be excused to continue to confer. Mr. Cornelius, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge. We're waiving PFI.
All right. Anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right. So everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winnington District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now, 922M. 18 USC 922M. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered a deferred adjudication from the state. He's accepted it pursuant to the court's approval. As part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he were to be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right. That is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right. Are you employed?
Yes, ma'am.
What do you do?
Pack and moving. Apple moving service.
Okay. All right. This is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting. By Zoom or in person. Regular UAs. 200 hours of community service restitution. There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits, 1 time per month for 3 months. And probation, if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubreyreed, Charlie James Ray Perkins, Amari Emari Lafel Lafel Freeman Freeman. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs?
Your Honor, the bill would say 1 time or just for 3 months.
Yes.
Your Honor, that's
All right, is there anything else you need from the court to have Black excellence in your life?
Oh, ma'am.
Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
Oh, ma'am.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself two questions. One, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
First, finding the guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. In regard to the no contact order with Jesse Wheeler, the parties are cohabitating. They do share a 5-year-old son who just started school yesterday. My client works at Pepsi during the day. Mother works for Rackspace at night. So the no contact order would impose an unduly burden on the parties in respect to parenting this child. As is usually the case, Your Honor, in these situations, CPS was involved as per family-based service plan. The parties went to counseling. My client went to counseling and is continuing to go to counseling. Both parties have been and are attending marriage counseling at this time. My client says that it's been a good influence on both them and their relationship. And they feel that the no contact order, if implemented, as mentioned, would be a burden not only on their relationship, on their status, but their ability to parent the 5-year-old child. So we respectfully request that the court not order a no contact order. Thank you.
All right, so is this a son or a daughter? Because I was reading the report, it was a daughter.
Little girl, sorry.
Okay, no problem. I want to make sure I have it right. So what family members do you have in Bexar County?
I have my mom, my dad, but my dad, he doesn't really help out much. My mom, she really can't because she can barely move around herself. Oh, I'm sorry. My dad, he doesn't really help. And my mom, she can't because she physically can't move around to help watch my 5-year-old.
All right, so here's the thing. I'm not going to do a no harmful or injurious contact. If there wants to be a no contact order, then the complainant can appear by Zoom or either in person. I want you to understand something.
Yes, ma'am.
I read the police report, and in the police report, you said she was pushing your buttons, you're pushing her buttons, and you can unfold your arms. And all of you all were acting not as adults. Y'all were acting like children. And the child at the time was 4 years old. You all caused drama and trauma to a 4-year-old. What is a 4-year-old supposed to think? And you and the complainant are going through the apartment, throwing things around. And you tell a 4-year-old, don't throw that, place it back where it's supposed to be, and trying to lay down the law to a 4-year-old. And you all are acting worse than the 4-year-old.
Yes, ma'am.
And that's a memory that 4-year-old is going to have forever. No amount of counseling that you all go to try to put your life together is going to take away that the 4-year-old witnessed all of this drama in their life. So if he wants to have contact with the mom and they're working things out, she needs to appear by Zoom and the court will consider it. If you want to get her to Zoom in here today, then I'll consider it today. Is she able to Zoom today?
She's asleep because she works at night.
Oh, well, if somebody wants to call her and have her Zoom in.
I can call her.
All right. So it's going to be 2 years deferred adjudication, affirmative finding of family violence, no contact with Jesse Wheeler. Of course, if you call her and she Zooms in today, I'll reconsider. The BIPP course, 80 hours community service restitution. I'm going to order parenting classes. If you've done parenting classes through CPS, that will be acceptable. If you have not, then you'll need to do parenting classes. If he's completed parenting classes related to this incident through CPS, then the community service hours will be deemed to be satisfied. There's to be anger management. There's to be CPS compliance. It sounds like it's a safety plan. So whatever the safety plan is giving them, just make sure he's doing that. And probation, if what he's doing for his CPS safety plans coincides with what I'm requesting, then the CPS, what they're doing will be enough. There's going to be regular reporting by Zoom or in person, regular UAs, and field visits one time. Well, field visits, I want at least 3 field visits throughout the entirety of his probation. So you only have to do 3. If you deem that there's something that's an issue, then of course you can do more, but a total of 3 field visits throughout his probation. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else you need? Jesse, Jessie, Wheeler, Wheeler. That may not stand if he's able to get her to zoom in. Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. Here's the thing. When there is violence in a home, children learn how to behave, right? So if somebody wins an argument by being violent, guess what? A child realizes, hey, if I want to win an argument, I need to be violent. Or here's the thing, you have a daughter. A daughter will think that you love her mom, right? You love her. So a daughter will begin to think, oh, this is how somebody who loves you shows that they love you. They're abusive. And then your daughter goes out in the world, and if she ends up with, as my professor in high school would say, and I say professor because he was a doctor who taught us physics, he would always say, girls, do not end up with a joker. So your daughter may end up with a joker. Don't let her be, you be the reason she ends up with a joker. And he would give instruction to the guys too. So
a man appeared before Judge Stephanie Boyd for a family violence case connected to an incident witnessed by his young daughter. The defendant chose to waive his right to a jury trial and accepted a stipulation of testimony, and the court found enough evidence to move forward with deferred adjudication. His attorney asked the court to lift a no-contact order with the mother, explaining that the couple still lived together, shared parenting duties, and had been attending counseling. Judge Boyd addressed the emotional impact of the conflict on their child before issuing her ruling. The sentence included 2 years of deferred adjudication, an affirmative finding of family violence, parenting and anger management classes, community service, regular check-ins, and a firearm restriction. The judge closed with a personal message about breaking cycles of harmful behavior for the sake of future generations.